This is Ask a Lawyer with Blaine Cluton. I start out these shows by saying I'm an attorney, but I'm not your attorney. And while these are good episodes for getting to a starting point and getting a lay of the land, they should not be your endpoint. And if you still have questions at the end of any of these sessions, you should be talking to an attorney. Leave it to an attorney to say, talk to another attorney. But sometimes that's the best advice I can give. So the episode topic today is I'm going to touch briefly on a couple ideas on estate planning. And the questions revolve around two main topic areas, and that's wills and power of attorney. And so the first question around wills is, can I handwrite my will? So I'm first going to go into some details about wills, and then we're going to talk about the question, do I need a power of attorney? So before I do that, when I think about wills and how this topic usually comes about as I'm talking to folks in my office, I'm often reminded of law school. And I'll never forget, as I'm sitting in law school and we're still using whiteboards and sitting in these big lecture halls, and the teacher has the whiteboard at the front of the room and has written the names of different family members. So there's husband and wife, and then there's several kids written below them like a family tree. And then the professor starts Xing people out, as in they've died off, they've passed away. And it struck me as this is a rather morbid topic. And I know that as these topics are discussed, it can seem as if perhaps it's a little bit callous. But I'm always mindful that when people are in my office and they're talking about these decisions that they're making, I understand how important they are, and I understand why people spend so much time contemplating and trying to get these questions in their head sorted out and correct. So I respect that, and by no means am I not taking this topic seriously, even though it seems somewhat bleak as we are talking about it. But sometimes I guess that's how you have to deal with these tough topic areas, is trying to keep it light. So here's the question. It says, my dad died and my stepmother-in-law claims that she found a will that's handwritten and signed, but it wasn't witnessed, and they've been married about 3 years. So the question is whether or not this will is valid. And that's a good question. So let's talk about wills in general and what's the purpose of a will. So generally, what a will is instructions on how you want your property distributed after your death. And if you think about the word will, as in thy will be done, what you're essentially doing is willing how the property will be distributed. So sometimes it's good to take a step back and think about it from that perspective about the meaning of the word and what it's intending to do. So let's talk about this a little bit more. Can I handwrite my will? Well, generally a handwritten will is treated the same as a typed will. Let's talk about the general requirements of a will in Oregon. And I'm an Oregon-based attorney, so all of my knowledge is going to be around Oregon, and I don't have licenses in any other state. So the requirements for a will in Oregon is you must be at least 18 years old. The will has to be in writing. It must be signed, and it must have at least 2 witnesses. And the 2 witnesses can't be beneficiaries under the will. They can't be heirs under the will. So they have to be disassociated from the will itself, disinterested parties. There are some other nuances to wills. If a will is executed with the same formalities or the formalities that are required in another state and they're executed in that state, so for instance, if Arizona has certain requirements for will execution and a person has executed a will in Arizona and now their property is being probated in Oregon, so long as they followed the rules in Arizona, Oregon is going to consider that to be a valid will. Also of note is that there's a fairly recent law change in Oregon, and when we refer to laws, we call them the Oregon Revised Statutes, and those statutes have changed recently, so that law has changed, and it allows for wills that do not meet all of those certain formal requirements. So the best thing that I can say in this particular situation for this individual that's wondering what to do is to go and talk to an attorney and discuss those options about contesting the will. What the new statute does at this point, in my opinion, is it's vague, and it's probably going to lead to protracted litigation, expensive litigation. So you're going to be needing to consider the value of the overall estate and whether or not it's worth fighting and contesting that will. So the best thing to do in your circumstance is talk to an attorney. As far as best practices and recommendations for people on wills, since this first question was about can a will be handwritten, it can. So your will can be handwritten, but it's just so much better and a best practice to type it for the reason that if it's typed and then signed and then following all those other formalities, then there's no question that there's been no change from the original will that you did. Whereas if you have a handwritten will, that will could have been changed at some point, and those changes either could be obvious or not obvious, but the person, it lends itself to being contested more easily by heirs later on if it's a handwritten will. So in all of my estate planning practice, what I'm usually guiding people on are, and one of the best things that I can do as an attorney is, how are we going to avoid protracted probate litigation once the party has passed away? Because most people don't want that. That's the whole purpose and the reason that they're creating the will in the first place is for finality. And so the property is distributed in the way that they want it distributed, not to lead to a bunch of litigation and fighting between the heirs. So if you're wanting to avoid that, then best practice is to have it typed out. So now moving back into, do I need a power of attorney? Couple of things that are really important to know about a power of attorney. They're only effective during your lifetime. So once you pass away, that power of attorney extinguishes. What often people confuse power of attorney with is a personal representative or an executor of an estate. Those are actually terms that are written into the will itself about who's going to be your personal representative or your executor for your estate. The power of attorney is only while you're living, and generally speaking, what it's for is to give financial authority to another person. Some things to know about power of attorney is if you haven't indicated an end date, then on the power of attorney, so if it doesn't have an expiration, then it's considered durable. And that means that the power of attorney will continue to exist even if you become incapacitated. And incapacitated could be either some mental incapacitation or it can be a physical incapacitation where you can't get out of bed for some reason. So that's a general thing to understand about durability and a power of attorney. When you are creating that power of attorney, you generally are assigning an agent, and that agent is a fiduciary that has certain responsibilities to act on your behalf. The power of attorney can either be a grant of specific powers, in which case the power of attorney is limited. And for instance, you may, in your power of attorney, give the agent access to specific bank accounts only and no other powers. So that would be a specific powers limited power of attorney. And the other general version of a power of attorney is what's called a general power of attorney. And that is the broad power of attorney where that agent steps into your shoes for all decisions that would be made. So essentially everything that the principal could do, the person that's creating the power of attorney, the agent can now do on their behalf with that general durable power of attorney. So as far as when that power of attorney takes effect, there's typically two ways that we write these. Either they're going to be springing, that some condition has to happen before they're effective, or they're immediately effective. So immediately effective on signing is the most common way. And what that means is that as soon as the general durable power of attorney is signed, that agent has the authority to act on the principal's behalf. But the other way of doing it is to make it a springing on some condition. So it could be once you reach the age of 81, then the power of attorney takes effect. Or upon my incapacity as determined by 2 doctors or a court order, that the power of attorney takes effect. So those are generally the different ways that the power of attorney would take effect, either immediately or springing. So the initial question on power of attorney, which I should have started with on the top, was, it says, I'm 65 years old. Do I need a power of attorney? And the short answer to that is, I always recommend, as part of a comprehensive estate planning guide process, that you should be looking at a power of attorney along with several other things. So you should be looking at a will or a trust. You should be looking at a power of attorney and advance medical directive. And along with that, HIPAA or medical releases. You should also be looking at a living will. And with a lot of people, I recommend either pre-planning their burial or whatever services they're going to have for funeral, or at least to create some sort of in memoriam guidelines for their loved ones to follow. So along with that, the one other general piece of advice that I give to people as they're aging, maybe not a 65-year-old, but if you're 65 and having a lot of significant health problems, then you would also potentially look at what's called a POLST, a POLST. That's a document that you fill out with your doctor. They're generally effective for 1 year at a time. That's the document that's a single page and usually filled out in triplicate, where you keep one copy and you put it on your fridge in case the EMTs come over and they know what to do in that emergency medical situation. So if you're 65 and you're wondering, do I need a power of attorney? You should be thinking about it, and you should be at least executing a power of attorney that would be springing into effect later. If you can't trust the agent that you're assigning these duties to in the future, or if you can't trust the agent now as you've assigned them powers immediately, that's one of the conversations I'll have is, do you really want this agent to have all this authority over your financial accounts? And if you're unsure about it, maybe it's time to look at another person to be your agent so that they're going to make sure they're taking good care of you. And this is all part of that planning process. So this is not a quick process, and it's generally done in steps so that the client or the person doesn't feel rushed to any conclusions. This is their life that we're talking about, and these are end-of-life care decisions that they're having to make. That's been the topic areas that I wanted to cover for today. I know it's been fairly short, but what I'd ask of people that are listening to this is to please share these episodes out with other folks. I've covered a lot of different topic areas and a lot of ground, everything from false accusations and spousal support in a couple episodes. We've talked about intellectual property, and now we're talking about estate planning. We've talked about so many different topic areas that touch people's lives in so many different ways that I'm really hopeful that these episodes are being shared to other people. And I would say that they are, because according to the information that I'm seeing, the downloads continue to increase, which means that the show is gaining in popularity. So the people that have shared so far, thank you. I really appreciate it. And if you are listening and you haven't shared it yet, please share it with a friend. I would really be grateful if you do. This has been Blaine Cluton for Ask a Lawyer. Until next time, this podcast is adjourned.